Welcome everyone to Covenants Not to Compete, Understanding the Legal Landscape in 2025. To send a question to the presenter, type in the box below the Participation tab. Materials for this course can be downloaded from your Supplements tab. Finally, we encourage everyone to take a few brief moments after the presentation to complete a short survey. That link can be accessed under your viewer window. It's now my distinct pleasure to turn the program over to our presenter, Neil Schur of Anderson Kill. Neil, the floor is all yours.
Thank you. And thank you all for joining this program. I hope it's helpful and informative. We're speaking now at an interesting moment in the evolution of the law of this area. As you may know, there have been some recent changes in the last couple of years in this area. And if you don't know, you will by the end of today. So it's an interesting time to talk about this topic. Here's the disclaimer. These are my views, not those of my employers or clients or any other organization. And these are for educational purposes only and are provided only for use during the session. They do not constitute legal advice or risk management advice. I am a shareholder at Anderson Kill's Philadelphia office, and I'm a commercial litigator, both state and federal courts, and I frequently speak and write on various topics. I'm also the co-chair of our Antitrust and Unfair Competition group, and I have both litigated cases and counseled clients on these topics. So let's start with a definition. What are covenants not to compete or non-competes? They are a type of restrictive covenant, and so they restrict what one party can do, typically the employee, and they are contractual agreements between an employee and employer in which the employee promises not to compete with the employer for a specific period of time or typically within a particular geographic area if the relationship between the parties should terminate. So if the employee leaves or separates from the employer, the employee is promising not to compete with that employer for a certain period of time. Traditionally, these were governed by state law, and as you'll see, there's been a brief foray into the possibility of federal law governing this area. As of now, I am predicting, it is my opinion that the Federal Trade Commission rule will not prevail and will die. And so the area will continue to be governed by state law as it has been for quite some time. So as you may know, in early 2023, the Federal Trade Commission, obviously a commission of the United States government, led by the chair, Lina Khan, who's been a very aggressive antitrust enforcer and creative enforcer, introduced a proposed rule that would ban employers from imposing non-competes on their workers in most instances in the United States. Specifically, it would make it illegal to enter into or attempt to enter into a non-compete, maintain a non-compete, or represent that the worker is subject to a non-compete. There were exceptions to the rule for existing non-competes for senior executives in policy-making positions earning over $151,164, and for non-compete clauses agreed to in connection with a bona fide sale of a business entity, of the person's interest in a business entity, or substantially all of the business entity's operating assets. As we're going to see, the rationales for non-competes in connection with an employment contract or employment relationship, I should say, are very different from those that are arising from agreements that are ancillary to the sale of a business. And the employment agreement non-competes are going to be reviewed with far greater scrutiny. Why did the FTC want to do this? What was their rationale? The FTC contended that this practice of using non-competes suppresses wages, hampers innovation, and blocks entrepreneurs from starting new businesses. The FTC estimated that its rule would impact about 30 million Americans and boost wages by nearly $300 billion per year with a B, a large impact. Now, as you may know, the Federal Trade Commission, along with the Department of Justice Antitrust Division, are the two federal antitrust enforcers. But typically, the FTC has engaged in procedural rulemaking, not substantive rulemaking. And so many viewed this as an abuse of its power and overreach of the agency, or the commission, I should say. And the FTC tried to defend itself with certain provisions within the Federal Trade Commission Act, and that has been met with mixed responses, as you'll see. Okay, so this was sort of I would say, branching out into a new area for the FTC. The FTC contends it was not, but in my opinion, it was different, new and different. That doesn't mean it was improper, but it was new and different in my estimation. Moreover, the FTC also estimated that banning non-competes would result in reduced healthcare costs. You can see that a range of $74 to $194 billion in reduced spending. It's a huge range, but even at the low end, it is a very large number. New business formation with a 2.7% increase in new firm formation, with 8,500 new businesses created each year, and a rise in innovation, which they measured by more patents, 17 to 29,000. So in April 2024, about a year and a quarter later, the FTC voted 3-2 and passed the rule. It was scheduled to take effect on September 4th, 2024. Now, that 3-2 vote is significant, mainly because the vote was along party lines, and the two dissenting commissioners were the Republican commissioners, who will now shortly be in the majority, as we're going to see. So that is significant. The FTC's rule faced immediate legal challenges, and I'm highlighting three. There may be more than this, but these are the three I've focused on. There were federal court challenges in Pennsylvania, Florida, and Texas, and each court ruled differently. So we have three different responses to the rule. And the challenges were seeking injunctions banning enforcement. So in Pennsylvania, the court denied the motion for preliminary injunction, let the rule stand, finding that the plaintiff had failed to establish irreparable harm or a likelihood of success on the merits. In that decision, the success on the merits turned on whether the FTC has the power to engage in substantive rather than merely procedural rulemaking, as I referenced earlier. The court stated, quote, "When taken in the context of the goal of the act and the FTC's purpose, the court finds it clear that the FTC is empowered to make both procedural and substantive rules as is necessary to prevent unfair methods of competition." The court further noted that Section 5 of the FTC Act empowered and directed the FTC to prevent unfair methods of competition and unfair or deceptive acts or practices in competition. The court reasoned, quote, "If the court adopts plaintiff's interpretation of the act, it would limit the FTC's power to only responsive or remedial methods of addressing unfair methods of competition through adjudication, which is inherently at odds with the ordinary interpretation of the word prevent." Some felt this was a very generous reading of the word prevent, but the court has an argument. Certainly the word prevent does not seem to address only things that have already happened. So it can do substantive rulemaking according to this court. That challenge, that case was eventually dropped after this ruling. In Florida, a federal court ruled very differently. There, the court granted the motion for preliminary injunction, enjoining enforcement of the rule, but limited the scope of its ruling to the plaintiffs in those cases. The court found it substantially likely that the rule presents a major question under the so-called major questions doctrine, and found that Congress has not rendered a sufficiently clear expression of legislative intent to authorize the final rule under that doctrine. The court noted the FTC, quote, has never tried substantive rulemaking of this magnitude before this, and had never even brought non-compete enforcement actions until it announced some consent decrees literally the day before it announced its notice of proposed rulemaking. As to Congress's expression of intent to authorize, the court explained an administrative agency's power to regulate must always be grounded in a valid grant of authority from Congress. With a rule as sweeping and consequential as this one, the Section 6 language, both by its text, placement, context, and history, falls short. The FTC has appealed that ruling to the 11th Circuit, and that appeal is currently pending. Then moving to Texas, a federal court in Texas also granted the motion for preliminary injunction and granted a motion for summary judgment, permanently enjoined the FTC's enforcement of the rule nationwide. This ruling was not limited to the parties in this case, and as a result of this ruling, the FTC rule is not in effect. The court found the FTC lacks statutory authority to promulgate the non-compete rule, and that the rule is arbitrary and capricious. Thus, the FTC's promulgation of the rule is an unlawful agency action. It further found Section 6G does not authorize substantive rulemaking, and that the rule explained that the rulemaking was arbitrary and capricious because it was unreasonably overbroad. The court cited the Supreme Court's recent Loper-Bright decision. As you may know, that decision, which received a tremendous amount of publicity, overturned the longstanding Chevron doctrine of deference to agency decisions. The FTC has appealed this ruling to the Fifth Circuit, and that appeal is pending. I should add that, in particular, the court found it significant that Section 6 does not prescribe any sanctions or statutory penalty for violating rules promulgated under that section, suggesting an authority only to issue housekeeping rules, which the ban on non-competes decidedly is not. The court concluded, quote, after reviewing the test, structure, and history of the Act, the court concludes the FTC lacks the authority to create substantive rules through this method. Section 6G is indeed a housekeeping statute, authorizing what the Administrative Practices Act, or APA, terms, quote, rules of agency organization, procedure, or practice, as opposed to substantive rules. As to its arbitrary and capricious finding, in line with concerns raised by many when the rule was promulgated, the court took issue with the rule's one-size-fits-all approach, with no end date. According to the court, the FTC could not adequately explain why it selected a sweeping prohibition over a more targeted approach aimed at the most harmful non-compete agreements. As we're going to see, a number of states have taken aim at, in a more selective, focused approach, have taken aim at the most harmful non-compete agreements, which economists generally agree are those that affect lower income individuals, lower income employees. The idea is that those employees lack bargaining power and can get stuck into a position with a non-compete that they really had no power to negotiate against. So where does this leave us right now? Where does this leave you? I believe that following the presidential election, the non-compete rule is likely dead. As I alluded to earlier, Republicans will soon hold a majority of the 5-member FTC and will likely withdraw the pending appeals, effectively killing the FTC rule. Even if the appeals are not withdrawn, I believe the FTC will likely lose its appeals of both decisions in the 5th Circuit and 11th Circuit and at the Supreme Court. I'll explain why I expressed that opinion. So first, as to the FTC, The FTC is an independent commission, but as you may know, the party in control of the White House nominates a majority of the commissioners. So following the election, Commissioner Ferguson has been named the new FTC chair, and Commissioner Holyoke, who was a commissioner previously, will continue. Those were the two votes against the rule when it was voted on back in April 2024. Mark Meador is going through the confirmation process, and in fact, just yesterday, there was a hearing with Mr. Meador before the Senate Committee on Commerce, Science, and Transportation. And some interesting comments Mr. Meador made at the hearing. He actually discussed non-competes. He said that the agency should, among other things, focus on the abuse of non-compete agreements in employment contracts. And he said non-competes have been overused and abused. There's a lot more the FTC can do, including with competition enforcement actions. He also said this week that he is launching a task force at the FTC, if confirmed, to investigate non-compete agreements and no hire and no poach contracts. So those comments are interesting. He clearly is concerned about the abuse of non-competes in employment contracts. So it is unclear if he will vote for or against the rule. At the time I prepared this presentation, was not aware of those remarks, but I will still predict that the FTC will withdraw its appeals, and he will pursue other options at the FTC with his task force. I also believe that the Fifth Circuit is likely to affirm the Texas District Court's ruling if the FTC does not drop its appeal, and the Supreme Court is likely to decline to hear the case or affirm the Fifth Circuit's ruling. That would resolve both cases. Alternatively, the court could hear both challenges together, and in that case would again likely find the rule arbitrary and capricious and an overreach of the FTC's rulemaking authority. Why do I say that? I say that because the Supreme Court is dominated by Republicans, and I also think who generally oppose this rule. And I also think that the court's recent ruling in the Loper-Bright case signals their antipathy towards overreach of government agencies. And this FTC ban has been widely criticized as an agency overreach. Some love it, but many are unhappy with it. The idea that 5 unelected officials could wipe out literally thousands and thousands of non-compete agreements that have already been negotiated and entered into was controversial. And remember that if you've negotiated an employment package for someone with a non-compete, then it may affect the compensation. The employer may be paying more compensation because they get a non-compete. If you wipe out the non-compete, there is a risk that the employer would be overpaying the employee, and that would be unfair to the employer as sort of a retroactive imposed rule. So that is my sense of what will occur here. If the appeals proceed, they will be overruled. I think as a result, non-competes will continue to be governed primarily by state law. Now, that doesn't resolve the question for many people because state law governing state law varies significantly from state to state. And so, and as you know, many companies operate in multiple states and many employees work in multiple states. So your relationship with an employee or an employer may be governed by different laws. So the law governing, for example, if you're a company based in Pennsylvania and you have a representative who works in Pennsylvania, New Jersey, and Ohio, and covers that territory, the law of New Jersey may be different from the law of Pennsylvania, which may be different from the law of Ohio. So you need to research carefully the applicable law of each state. And I would also monitor this highly dynamic area closely. As we're going to see, even state laws have changed somewhat in some states in the last 2 years. I'm going to give you a little overview of Pennsylvania law, which is similar to many states, but is not the end all be all, and there are differences. So you, again, should look at your state's law. But I live and work in Pennsylvania, so I'm going to focus on Pennsylvania, and it'll, I think, give you a good flavor of the law, and many states follow similar principles. So first, as I alluded to earlier, Pennsylvania has long recognized a distinction between the hardship imposed by a restrictive covenant on an employee or former employee, more precisely, and enforcement in the sale of a business context. The covenants not to compete and that are ancillary to employment are subject to a more stringent test of reasonableness that is applied to restrictive covenants ancillary to the sale of a business. So that you're going to see that they're treated very differently. If you read cases in this area, you will see this concept over and over and over. And the reasoning is this: if you have a covenant not to compete that's ancillary to a sale of a business, it has a useful economic function. It protects goodwill that the purchaser has bought. And as this case, this Prin case is quoting the Morgan's home equipment case, but there's a great quote that is often, recirculated that says, in many businesses, it is the name, reputation for service, reliability, and trade secrets of the seller rather than the physical assets which constitute the inducements for sale. Were the seller free to re-enter the market, the buyer would be left holding the proverbial empty poke. So it's that empty poke you're trying to prevent, and that's why courts will allow covenants not to compete ancillary to the sale of a business much more readily. Okay. So this may sound obvious, but this is actually dispositive of a number of cases. At a minimum, for a non-competition or restrictive covenant to be enforced, it must be reasonably related to the protection of a legitimate business interest. Okay, that sounds obvious, but it is not. And if you are going to have a covenant seeking merely to eliminate competition per se, or give an employer an economic advantage, is generally not enforceable, as the Hess court explains. So you can't just do this to promote your the employer's profitability. What types of interests are kosher, are permissible? Well, the types of interests that have been recognized in the context of a non-competition covenant include trade secrets, confidential information, unique or extraordinary skills, customer goodwill, and investments in an employee specialized training program. So those types of things are going to be typically allowed as reasonable, legitimate business interests. That is a threshold requirement for an enforceable non-compete. If you don't have a protectable, legitimate business interest, it's going to be struck down and found to be unenforceable or invalid. In the employment context, by contrast, the restrictive covenants are generally disfavored, and the law likes to say that, but even notwithstanding that, they allow them. So I always find it sort of amusing or disingenuous that they make this proclamation that these are generally disfavored, but they are allowed as long as there are sufficient restraints and restrictions. Okay. At a minimum, no, I'm sorry, a governing, I apologize. The other thing you want to think about is consideration. So like any agreement, you may go back to your law school days, any agreement needs offer, acceptance, and consideration. Non-compete agreement is the same. And it is not enforceable unless consideration is given in exchange for the covenant not to compete. So what does that mean? When do you have to give consideration? These employment is considered, and what counts as sufficient consideration? Employment of the party agreeing not to compete is sufficient consideration if the parties agree to the non-competition provision at the start of the relationship, or that the employee at least knows that the non-compete agreement is a condition of employment at the time he or she starts the job. So let's say employee starts work in 2022, and in 2025, right after this presentation, you go back to your work and say, oh, we need to get non-competes in place. So you hand out non-competes, you force everyone to sign them, require it, and then someone allegedly violates it. You go to court, and the court says, well, what was the consideration for that agreement in 2025? You have nothing. That agreement is not enforceable, okay? After the employment relationship has begun, continued employment on the same terms is not sufficient consideration for a non-competition agreement, and absent new consideration at the time of the non-competition agreement, the non-competition agreement is not enforceable. This is important, and this often disposes of a number of cases as well. Oh, my lights just went off. I apologize. Okay. So to sum up, restrictive covenants such as non-competes are, quote, strongly disfavored, and they are strictly construed, but they are enforceable if they are incident to an employment relationship between the parties. The restrictions imposed by the covenant are reasonably necessary for the protection of the employer, and the restrictions imposed are reasonably limited in duration and geographic scope. So you may remember, if you've studied antitrust law, some claims in antitrust law, some restraints of competition, restraints of trade are subject to what's called a per se rule, and some are subject to the rule of reason. This is not exactly the same thing, but essentially this balancing test is essentially a rule of reason. So in antitrust law, some things are so egregious, you don't need to prove anti-competitive effects or establish the market in the same way you do in a rule of reason case. Here, in a rule of reason case, you have to show that the restraint is unreasonable. And the same thing is true here. You can have a restrictive covenant in an employment context as long as those restrictions are reasonably necessary and reasonably limited in duration and geographic scope. As long as I mentioned, that there is consideration and that there is a legitimate, protectable business interest. Let me just reinforce that. So there's the case Morgan's Home Equipment, which is cited in these papers. And in this case, this is an older case from 1957, but the court found that there was no genuine legitimate interest for the employer to enforce the covenant. There's a quote, the record in the present case discloses no evidence that the employees received any special training or insight into methods of doing business of the plaintiff company, which would make it inequitable to have them compete with the plaintiff for the patronage of the public at large. Although the defendants obtained confidential customer information, the company was adequately protected by the decree which enjoined disclosure and solicitation, and so prevented the former employees from benefiting from their customer contracts and knowledge. Consequently, under these facts, we find the general covenants not to compete are not reasonably necessary for the protection of Morgan and constitute an undue hardship upon its former employees. In another case, more recent, the Piercing Pagoda case, this was a franchisee that would pierce people's ears and set up kiosks in malls. You may have seen their operations. They found that the franchisee, hold on one second. Yes, by the use of the franchisor's name and ability, the franchisees availed themselves of the beneficial provisions of the franchise contract. In so doing, they made use of the franchisor's name, which the law recognizes as a protectable interest. So if you're in the franchise context, that would be a legitimate protectable interest that they can be protected by a covenant not to compete. And finally, I want to highlight the Hess case, which I previously cited. This case, the court found that there was not a legitimate business reason or interest to protect. The court found Hoster has not demonstrated that the information it seeks to protect, mainly its prices and customer lists, is particular or unique to its business and deserves protection as a trade secret or confidential information. In point of fact, there are no trade secrets or proprietary information relative to Hoster's prior insurance business that are germane to the conduct of the current real estate business of Hoster. Moreover, the potential customers that were available to Hoster's insurance business were the same as those that were available to Gebhardt or any other insurance agency operating in Lebanon County, and the identities of potential clients were widely known and easily available. If the information the employer seeks to keep confidential could be obtained by legitimate means by its competitors, enforcement of the covenant on that basis is not appropriate. So I think that gives you some flavor of the importance of legitimate interest. On the issue of consideration and the timing of consideration, if that issue comes up for you, should consult the Rolex case, R-U-L-L-E-X case that is cited in my papers. This is a Supreme Court of Pennsylvania case from 2020. It's pretty recent. And they discuss a number of cases and the different rulings of exactly when you need to agree that the employee will be bound by a restrictive covenant, covenant not to compete. The court acknowledges that a restrictive covenant, such as a non-compete, understood by the parties at the outset of the employment relationship as being part of their overall arrangement, might not be physically executed on the first day of work. So the person might start work and sign the actual covenant on the third or fourth day. We've all started new jobs and there's a flurry of activity that may delay the actual signing of the covenant. That does not kill your claim as an employer that there was an agreement at the outset as to this covenant. So for example, the Beneficial Finance Co. case, the court determined that a restrictive covenant was ancillary to the taking of employment and enforceable, where it was contemplated at the inception of the employment relationship, signed on the third day of work, and accepted by the parent company on the 12th day of work. Okay, but it's not a bright line rule, and it's a case-by-case analysis. So if you look at the National Business Services case from 1998, it found that a non-compete agreement was enforceable where it was contemplated before employment began and the employee signed it on the 10th day of work. Conversely, a restrictive covenant executed on the first day of work may be unenforceable if the parties had previously reached a binding oral employment contract that did not subsume the restriction. That was in 1975 case, George W. Kistler, Inc. versus O'Brien. So it has to be early on in the employment relationship, and really before the employee starts work, there should be an agreement. Whether it is physically signed or not is not necessarily the key, but there needs to be an agreement or a meeting of the minds, if you will, between the employer and employee as to this covenant not to compete. Otherwise, it's void for lack of consideration. So what is reasonable? Generally, 2 years is held up. As you can see in these cases, Fitness Essentials, Metro Public Adjustment. As you go out from that number, you could be upheld, but you're not going to get 20 years upheld. If you're not going to get 30 years upheld, 2 years, 3 years, that could likely work. 4 years, it depends on the business. You're going to look at a fact-to-fact factual analysis of the case, the circumstances and facts of your case. And the same with respect to geographical limitations. Courts will look at the scope of the area in which the employee has performed services and developed a customer base, as well as the scope of the geographic scope of the employer's business. Where is it going to have an impact? Where is it reasonable to restrict the competition? So this balancing test, I want to go back and add one point I forgot to mention. The balancing test of saying a restrictive covenant can be enforceable if there are reasonable limitations on the time and geography. That started back in England, back in 1711, in a case called Mitchell versus Reynolds. They're balancing between the employer's protectable interest and the employee's right to work, because you are restricting an employee in his or her ability to make a living. And this is very important, an issue that we really have to take seriously. And this has been discussed recently in the Hess case. As I said, covenants not to compete must be reasonable with respect to geographic scope and duration, and the inquiry as to what is reasonable is fact specific. So if it is enforceable, the typical relief is an injunction barring the employee from continuing to compete. Courts have rejected arguments that money damages are ascertainable. For example, there's the Clifton case that is cited in your materials, where an employee argued that an injunction was not appropriate because money damages were sufficient to protect the interests of the employee. But the court found that quote, the covenant seeks to prevent more than just the sales that might result by the prohibited contact, but also the covenant is designed to prevent a disturbance in the relationship that has been established between appellees and their accounts through prior dealings. It is the possible consequences of this unwarranted interference with customer relationships that is unascertainable and not capable of being fully compensated by money damages. And it cites the Bettinger case, which is also cited in your papers. And so a covenant of this type meets the test of reasonableness and is prima facie enforceable in equity. So those two cases are informative if you are confronted with that issue. So that's just an overview of Pennsylvania law. Although many states do take a similar approach to that of Pennsylvania, non-competes, particularly as to lower income employees, as I mentioned earlier, have been under attack in recent years. In the last 2 years, various states, they're listed here, Massachusetts, Colorado, Maryland, California, have tightened their bans or implemented new bans on non-compete agreements. And in fact, New York almost did the same until it was vetoed at the last minute by Governor Hochul. Other states have older bans. For example, these states, and this is where I think you're going to see growth in the next year or two, 3 years. These states have passed bans that focus on the lower income employees, and they have widely varying thresholds for what constitutes a lower income employee. But the principle is the same, the numbers vary. Virginia, you see employers cannot enter into, enforce, or threaten to enforce a covenant not to compete with any low-wage employee defined as 76,000 or below. Washington is the state of Washington, bans non-competes if you have an income less than a threshold amount, 123,000 or 308,000 for independent contractors. In Washington, D.C., non-competes are prohibited if the employee earns less than 154,000 or 250,000 for medical specialists. That the threshold for 2025 has not yet been released. Colorado, 127 threshold. Illinois, up to $75,000 a year. They've set a schedule to increase it every few years. It will increase in 2027. Maryland, non-competes null and void up if you're earning up to 150% of the minimum wage, which is currently $15 an hour. So that would be $22 an hour or below. No, you can't have a non-compete. There hasn't been a threshold announced for this year, calendar year. And Massachusetts is the same principle, but their threshold is much lower, 35,568. What's interesting about Massachusetts is it says you can't have a non-compete against employees paid on an hourly basis. So anyone paid on an hourly basis cannot have a non-compete, or if it's below that threshold. So you can see, and this is not an exhaustive list, but it's a good representative sampling. It's an illustrative list, gives you a sense of the rules. And if you're in one of these states, you should look into this, your state's law more carefully. All right, I want to shift to a related topic, which is non-solicitation agreements. You may be familiar with these. This type of agreement prohibits an individual from soliciting employees or customers after separation. Sometimes it prohibits use of confidential information or proprietary information. Could be in a standalone document or could just be one clause in a contract. But this is another protection that an employer can use to protect solicitation of employees or customers. Both are widely used. And these are another type of restrictive covenant, so they're subject to the same rules and principles as before. Some states have also banned the use of non-solicitation agreements for employees under the stated income thresholds. There's also something called a no-poach agreement. This is a relatively recent trend. It was kind of in the news quite a bit in 2019. There were, first in the franchise context, you saw franchisors agreeing with franchisees that the employees could not be allowed to be poached from one franchisee to another franchisee. So if an employee were at location 1 of Dunkin' Donuts or Dunkin', then another employer, another franchisee, excuse me, could not poach those employees and bring them even within Dunkin' Donuts. So this was harmful according to the Attorney General of 14 states. And they reached an agreement with at least 4 franchisors, Dunkin', Arby's, Five Guys, and Little Caesars, to stop using those clauses. There was a multi-state coalition led by Pennsylvania and Massachusetts. Our governor, Josh Shapiro, was Attorney General then, and this was one of his pet issues. And the coalition also included a number of other states listed there. The Attorney General of Washington similarly also targeted no-poach clauses in franchise agreements and sued Jersey Mike's and settled, and also reached agreements with 23 fast food chains, including Burger King, Pizza Hut, Papa John's, Denny's, McDonald's, and Carl's Jr. So you see, this was a pretty widespread practice among these fast food franchises and donuts. Yeah, well, I guess they're all fast food. So you see that happening, and now it is being stopped. As of 2019, it has been stopped in many states. There was some guidance issued by the DOJ, the Department of Justice, and the Federal Trade Commission on this issue of non-ancillary no poaching agreements, calling them per se illegal if they are naked, meaning not ancillary to anything. And the DOJ also advised that legitimate joint ventures are not per se illegal, and has advocated for the rule of reason to apply. Now, that was back in 2016. The new administration under President Trump may revisit this issue. As I said, the FTC will now be under Republican majority control, and the DOJ will be, part of the Trump administration. So the guidance may be revised on no poaching agreements. I would stay tuned in this space as well. I want to turn to another type of agreement that is also relevant, another way that an employer can protect the disclosure and use of its confidential information, an NDA. So an NDA, as you probably know, is a legally enforceable agreement that protects disclosure and use of information, and keeps it confidential. Stating your purpose is important. Often it's too broad and too general. This can be a unilateral or mutual agreement. NDAs are used to protect these various things: customer lists, IP rights, trade secrets, and business plans. They are frequently used to facilitate business transactions. If two parties are contemplating a merger or acquisition or joint venture, they almost always have an NDA. It should create legal remedies and be specific what those remedies are. Ironically, we find that it builds trust, though I find it funny because there is no trust without it. So it builds trust. And maybe it's better, we should say, instead of builds trust, it gives people comfort that the other side will protect the information, because you now have trust only because you've signed the NDA. So to think about the key components, what is the purpose? You should state that clearly, and I'm going to discuss that in a moment. Who is covered by this? Are affiliates covered? Are all employees covered? Anyone who sees the information, things like this, you have to think through. And what is designated confidential? Certainly all information is not confidential, but you want to be careful what you designate as confidential so you don't have a claim of over-designation. And conversely, what is excluded, what is not confidential? Typically, you exclude information that is already public. Be careful to clarify and specify the obligations of the receiving party. Set a term. It should not be forever. The information will eventually be stale, and a court will be reluctant to enforce an agreement, an NDA that has an overly long term, because the information is no longer commercially valuable or proprietary. You should specify the penalties for breach. Courts have struggled with this and found that the parties didn't specify the penalty for breach. So if you have a penalty you want in mind, you should put it in your NDA. You should also include exceptions. The most obvious one would be for a subpoena or other civil process, but you would need to give notice requirements to the party whose information you're disclosing, give them opportunity to object, move to quash, move for protective order, etc. Mistakes to avoid: being too broad, vague, failing to include remedies, making duration indefinite, assuming you will not need to, the other party will not need to disclose the information, not addressing what happens to the information post-termination. We typically provide that it will be returned or destroyed with a certification of destruction. If you need additional protection, you can try to qualify the information as trade secrets, and we're going to discuss that in a moment. Though I see I am running out of time. I'm trying to cover a lot of material. I hope it's helpful. Not clearly specifying the governing law or jurisdiction can be a problem, and no contemporaneous execution. I would make sure you get this executed promptly. Here are some drafting tips. Example: purpose is to share information. It's really too broad. I would be more specific. The purpose is to share X types of information about Y product to evaluate Z properties for ABC project. Example 2, the disclosure period and the confidentiality period are 20 years. Try instead 2 years and 4 years or longer for trade secrets. This will be much more likely to be enforced. I'd recommend the best practice would be to have a template ready to go, and that includes all essential clauses, but is flexible enough to be modified to fit each unique situation. And you should modify your template to be specific and follow these other tips that I've given. So for maintaining confidentiality, best practices would be to issue and update internal policies and procedures for safeguarding the information and train employees on confidentiality obligations. You see this in NDA cases and in trade secret cases. If the information was loosely bandied about in the workplace, no one was told it was secret, and there was no training on its confidentiality and no safeguards in place to protect it, the court is going to look askance at your argument that it is confidential. You should have, if you store the information, you should have, if you put it on a shared drive, it should be restricted to those with a need to know, and only those can get the password. It should all be password protected and only give that password to those employees that are going to use this sensitive information, and train them that this is confidential, not to be shared or disclosed with others. Same thing if you happen to, you still use hard copies, and some businesses do still have hard copies in some form or some portion of their work. The documents should be kept in a safe place and only access should be restricted to those who need the information. This is what it says: implement physical and digital security measures, and you should regularly review and update NDAs as needed. If they only last 2 or 4 years, you can't issue them, have everyone sign them, and then let them expire. You need to redo them and update them so that their information remains protected. This expired NDAs is a real issue in the workplace. All right, so now let's turn to trade secrets. Some information may require heightened protection and may qualify as a trade secret. So there's a Trade Secrets Act in almost every state, and there's a Federal Trade Secrets Act we're going to discuss. They all have similar but not identical definitions of what constitutes a trade secret. So I'm giving you some information here from Pennsylvania's Trade Secrets Act. It is a version of the UTSA. So your state, if you're not in Pennsylvania, may be different. You should look at the law in your state. The definition here is that information could be formula, drawing, pattern, compilation, customer list, program, device, method, technique, or process. But it has to do these things. It has to derive independent economic value from not being generally known to or readily ascertainable by other persons who could obtain economic value from its disclosure. So again, not readily ascertainable, that's you making sure it's protected. And it's subject of efforts that are reasonable under the circumstances to maintain that secrecy. It has to have value, and you have to have tried to keep it secret. Here's another definition Pennsylvania courts look to, the restatement of torts, 757. It's very similar, but it's slightly different, okay? And as this case explains, the question whether something is a trade secret is a case-by-case analysis and can include confidential customer lists under certain circumstances. Here's the Superior Court's list in one case, the MJ Test Prep case. Superior Court's list of factors that trial court should consider in determining whether information constitutes a trade secret, and you can read them, but it's similar to what I've just gone over. Okay, how much effort or money has been expended by the employer? How valuable is this? And what efforts have you taken to guard the secrecy of the information? And how easily could it be acquired by others? Is it readily available to the public? I'm not going to get protection as a trade secret if it is. The crucial indicia for determining whether certain information is a trade secret or substantial secrecy and competitive value. So that's basically the same thing we just went over. If the competitor could obtain it legitimately, will not be given injunctive protection as a trade secret. If you disclose or use trade secret of another person without express or implied consent, if you've used improper means and knew you had reason to know that it was obtained improperly, I'm just going to summarize all those words by obtained improperly with dirty pool, you know when it's dirty pool, then that's called misappropriation of trade secrets. And you can bring a claim for misappropriation, or you could get sued for misappropriation. But if you knew or had reason to know that it was a trade secret and that you had acquired it by mistake or accident, that counts too. Or if you've intentionally stolen it or obtained it improperly, that is going to constitute misappropriation. What are improper means? Theft, bribery, misrepresentation, breach or inducement of a breach of duty to maintain secrecy, or espionage through electronic or other means. Hacking obviously would count. If you're an employee and you steal the information and take it for the use of your own startup company or a competitor's use, that would definitely count. And willful and malicious is defined here as such intentional acts or gross neglect of a duty as to evince a reckless indifference of the rights of others on the part of the wrongdoer and an entire want of care so as to raise the presumption the person at fault is conscious of the consequences of his carelessness. That becomes important when you're trying to seek attorney's fees. I should have done this a few minutes ago, but let me stop now. I have to read a code. This is for not for those of you who are attending live, but for others who are watching this later when it's recorded. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the certified legal edge audience, either live or on demand. I will read this code twice and only twice and cannot repeat it or email it to you. So please make a note of it. The New York State code number is N as in Nancy, S as in Samuel, 3533-22625. Again, the New York State code number is N as in Nancy, S as in Samuel, 3533-22625. All right. One moment here. Okay, so as far as relief, I mentioned attorney's fees. In addition to an injunction, you could get reasonable attorney's fees, expenses, and costs if you prevail. But note that the times when that is available often go to either side. So it's if a claim of misappropriation is made in bad faith. So if the plaintiff has exercised bad faith in claiming misappropriation, that could lead to attorney's fees, expenses, and costs. Similarly, a motion to terminate the injunction is made or resisted in bad faith. And finally, if willful or malicious misappropriation exists. So that third one goes back to the definition I read a moment ago of willful and malicious. Those attorney's fees may be sizable, and this could be a valuable lever in your negotiations and to deter such conduct. As I mentioned, there is a federal statute that governs. My lights went off again. A federal statute that governs trade secrets called the Defend Trade Secrets Act. It largely follows the Uniform Trade Secrets Act, but obviously requires interstate or foreign commerce. It does provide for a private right of action under 1836B. All right. So that is all I have for you today. I would say one thing I didn't mention is that when you are faced with a non-compete case, what typically happens is there is a big scramble at the outset of the case to gather the facts. And if you're the party trying to enforce the non-compete, you typically scramble to get your witnesses ready, and then you move for a preliminary injunction and you go to a hearing. And then you actually put on evidence even though you haven't even filed the case. It all happens very quickly. Or you file the case that morning and then go to the hearing that afternoon or the next day. It's very quick, and there's a lot of scrambling to get ready for that. And then that hearing determination often leads to a settlement one way or the other. That is the case often in sum and substance, because the court has ruled and signaled where it's going to go if there's a likelihood of success in the merits. So let me see if there are any questions here. Let me check this link. Hold on one second. No questions were found. Okay, please let me know if you have a question. You can ask it through the question option on your app, and it will appear in my on my screen through this link. It is now 12:57, so I don't know if anyone has any other questions, but I've covered a lot of different things here. When you look, if you're an employer looking to protect your information, you want to think through your strategy. So you have a number of arrows in your quiver. The topic here was covenants not to compete, because that's been in the news, but non-competes are just one piece. There's non-competes, non-solicit agreements, and then there's NDAs, and then there's trade secrets. So you can use all these things to protect your information. The courts do want to protect confidential information of an employer, but they also want to protect the interests of an employee in being able to work and pursue a living. So that's why we have this balancing test that requires reasonable restrictions on time and space. So let me check if there are any additional questions. Still see no questions. Okay, so if I were you, I'd monitor this space closely. This is subject to change, both on the non-competes in a given state and the non-competes at the federal level. I've given my predictions, but of course, they are just that. They are not the law. Right now, the litigation is pending for the FTC appeals in both the Fifth Circuit and the 11th Circuit. And I could be wrong, but my sense is those are going to be dropped and or unsuccessful. So I would stay tuned. Especially on the state level, I think you're going to see some changes on the state level in some states. And so you need to monitor the space to make sure if it's your state that is at issue. The California ban on the multiple state issue, I should note this, the California recent change, when California tightened its ban, it reiterated some of the basic principles of a ban on non-competes, but also said you cannot enforce a non-compete that was signed in another state. So you can't enforce it in California. So that's an interesting effort of the California legislature to weigh in on the multi-state issue, which does happen. In today's world, it is pretty frequent that representatives handle more than one state, or sales reps have a territory of more than one state. That is not unusual. So you may have different laws governing their conduct in one state versus another state. All right, by my computer, it is now 1 p.m. I'm going to refresh one more time to see if there are any other questions, and I'm happy to answer any questions after this presentation if you have questions. My email address and phone number are on the presentation, and feel free to reach out to me if you have questions or if you have a matter you need help with. All right, and with that, I think this concludes the presentation. I thank you all for attending and wish you a good day. Thank you very much.